Okay. Welcome to the Medical Law and Ethics lecture, specifically centering or being centered on medical negligence in Zambia. Now, in most cases, we hear a topic and an idea pops up into our heads, especially looking at the audience that is currently attending the session, being an audience that is, or that may be very foreign from the course at hand, which is medical law and ethics. This course is not just for law students. It is a course that any medical practitioner should take into consideration, especially if they wish to work here in Zambia or practice here in Zambia. I should mention for a start that the medical profession, as well as the law profession, are considered to be noble professions. Thus, there's a lot of regulation that is there when it comes to practice. Now, in most cases, you will find authoritative references being mentioned at the end of the session. But for this one, I want to just pay homage to Dr. Aaron Mujajati and Mr. Joseph Chilwa, two of the authors of the Mujajati and Chilwa on medical law and ethics in Zambia, a must-have for any person who would like to look into or try to understand medical law from a different perspective. This could be your foundation. It could be your foundation, and it has covered extensively quite a number of things, and it has touched on some of the things that we're going to discuss today. With that being said, let us jump right into our session for the day. Now, I did mention that medical negligence is attached to a broader branch of the law, and this is the medical law and ethics branch. It is that type or that branch of law that deals with the medical profession as a whole. But its main focus is on the relationship that exists between a medical practitioner and the patient, and the regulation of that particular relationship, as well as other factors that are adjacent to it. It could be relating to the rights that are conferred upon patients, such as patient autonomy and informed consent, all factors that are broadly explored when you start looking at the medical law course or the medical law and ethics course. Aside from this, it also tries as much as possible to talk about tortious actions that would come out of practice or that would come out of the profession itself, that is the exercise of the duties or the carrying out of the duties by medical practitioners. Now, let me pose a question to the audience. If either of you has ever gone into a public hospital or a private hospital and have been attended to so badly by a medical practitioner, it could be they were having challenges with their cannula or whatever it is. Maybe has any of you ever experienced such a situation where you go before a practitioner and you've been treated so badly or you've been handled so badly that you even swear that this is definitely not the standard that I'm supposed to receive? Maybe just from the audience, if anybody can volunteer to just tell us a little bit about such an experience. You can raise your hand and I'll unmute the mic. Has either of us any had such an experience? Yes, Marisha?
Um, so it wasn't directly me, but somebody related to me. Is that okay if I can?
Yes, it is. You can go ahead.
Okay, so firstly, my cousin. So she was giving birth using a C-section. Yes. So apparently, when she had given, they had operated on her, and then they were closing the wound. They sort of uh, left something inside. So I don't know how they did the whole thing when they were knitting and closing up. Then they left some cotton inside, and then it sort of started affecting her, and then it was rotting inside. But then when she went back to the hospital, they told her no, it was just okay, and then they just patient. So not until some weeks until it became worse, and then we were transferred to now the University Teaching Hospital, where we had discovered that our ovaries started getting damaged. And then another experience was with my mom before she passed. So she had a lump in her breast. So she went for the first operation. So apparently, when they did the operation and removed the first lump, I the doctors were not they were negligent rather. So they sort of left the other according to the information they gave us, it was fine. We removed everything, but then later on there was this problem that developed. Then when we went on to check, they said the operation wasn't done properly. There was something that had remained, which caused this now. So I've had those experiences with my family members.
Okay, thank you so much for sharing. That was very elaborate. Now, I'm sure there are people who still have had these experiences, either personally or have seen or noticed or basically just experienced it through another person of such a treatment. This is where now we need to center our focus on to what extent can we really consider a medical practitioner as being responsible for their actions which has caused harm, injury, or loss. Is it every mistake or is it every action that leads to such that we can make this particular person accountable for? Now, in order for us to answer that question, we need to understand these acts. There are several of them, but for the purpose of this section of this lecture, we'll focus on medical negligence. Now, medical negligence is equally referred to as medical malpractice. For those who are just meeting negligence for the first time, the Housebury Laws of England on the general principles of the law of negligence, 2010, in the fifth edition to be specific, defines negligence as a specific tort, that is a civil wrong. It is a specific tort, very specific, which arises in circumstances where there is a failure on the part of a particular person to exercise the care which the circumstances demand. This is what negligence is about. That is the basis. There is also medical. Now, medical in this sense is not used as an independent term, but rather referring it to the profession itself. So medical negligence thus will refer to the failure of a medical practitioner or professional to uphold and fulfill their professional duty, which they are expected of as a matter of their position. And this position is as a matter of their skill and knowledge, which is expected from them by virtue of them being a part of that particular profession. Now, before we get into the nitty-gritties of what medical negligence really is in the light of the law, maybe we try to understand where it is coming from. The theoretical justification for the creation of medical negligence. There's this concept called the fiduciary relationship theory. The relationship that exists between a patient and the doctor. It's usually called the physician-patient relationship. It is one that is heavily rooted in legal and ethical considerations. It is heavily rooted in legal and ethical considerations. The ethical side of it, speaking to the fact that the relationship that exists between these two is one that is heavily rooted in trust. So the patients submit themselves to medical practitioners or physicians with the mindset, or rather on the premise of trusting that these practitioners, these people who are holding themselves as medical practitioners, are well informed. They're not only well informed, but they are trained in their skill and craft. So this is the fiduciary theory, the fiduciary relationship theory, to be specific. So the relationship is fiduciary because it is based on trust. It is existing in the ethical sense of it in relation to trust. In the legal sense of it, it is a relationship that is premised on, say, a contract. It could be an agreement that is implied, an agreement that is expressed, depending on the circumstances, because you can have an express agreement in situations, for example, where you have to undergo surgery. You will sign contracts. You sign contracts, and those contracts will have terms to them. It could be a very dangerous procedure, and you decide to waive your rights to sue as a part of the clauses that are there. Or you waive your rights to claim for reparations in circumstances where the procedure does not go as is planned. Because there are so many situations and circumstances that could arise. There's so many scenarios. It could be that maybe your body reacts negatively to the medicine that you're given. It could be that as you are undergoing procedure, the medicine that you are given to reduce the pain, it loses its effects during the whole process, and you wake up and it's hurting. Maybe you were given some medication and then you overreact to it. You develop maybe rash or something like that. So how then do we justify the impositioning of penalties for failure to uphold an expected standard of duty by these persons who have the skill and have the knowledge? This is why we don't look at medical negligence from the angle of general negligence. It's because of the existence of this relationship rooted in trust, rooted in legal principles. And Their justification is that in a situation where we start considering general negligence, or medical negligence rather, in the same light as general negligence, there are going to be a number of cases that are submitted before the court for determination of whether or not this particular person is negligent. And in most cases, the professionals are going to be considered to be negligent under the general negligence scope. But when it comes to medical negligence, it is a whole different thing. It is a very different thing. And there's a lot that needs to be done in order for this notion to be put out there in the public. Because a lot of people would consider medical negligence and general negligence as the same. Thus, there's need for sensitization. In fact, this has been recognized in various jurisdictions and in court decisions that even the court itself at times do make decisions that are made without the consideration of the distinction that exists between the two. In fact, one of my favorite articles that I read about medical negligence, in fact, I wouldn't call it an article either way, but it is a dissertation that was written by Kangwa in 2015 from the University of Zambia. He wrote about medical negligence in Zambia, critically analyzing one of the cases that I'm going to refer you to later on, the DAF Kopa versus the University Teaching Hospital Board Management decision that was made by the Supreme Court of Zambia, acknowledging that even the courts themselves at times may miss the distinction and may decide in without due regard of this particular distinction, and its ripple effect is that it will affect approach that has been created insofar as this relationship is concerned. Now, there is now two circumstances that we need to consider in this particular situation. Firstly, we need to consider the patient. The patient has suffered injury, and it is just that they be compensated. At the same time, making medical professionals susceptible to general liability for negligence actions will now mean that firstly, the prices for this particular, for access to the prices for access to help is going to be very high. That's number one. Number two, we need to consider the protection of the profession. It being a noble profession, there is need for safeguards to be put in place so that we'd call them busybodies, those who run to court every now and then, do not abuse court process to unfairly bring medical professionals within the crosshairs of the court. Now, it is all about understanding the existence of this relationship that will be able to address these two issues and will be able to find common ground. The Supreme Court of Canada, in the case of Norberg versus Winrib, it is showing on your screen right now, did address these issues revolving around the relationship. So in that particular case, this physician did in fact take advantage of a young female's patient's addiction, and he prescribed painkillers, not because the young female patient needed to take these painkillers, but because he wanted sex in exchange for these particular pills. So he did in fact give those pills, in exchange for sexual actions. And when it was brought before the court did emphasize that the nature of the relationship that exists between a patient and a doctor is one that is not of self-interest. It is not of self-interest, but it is one that is built on trust, which is very, very fundamental. And the breach of such a relationship, a duty owed to a patient, should definitely be analyzed in light of serious consequences that would be imposed in circumstances where this particular person is found wanting. And the consideration should go through, it should go through and beyond, in fact, the tortious limitations or contractual doctrines. This is what Justice McLaughlin stated with respect to the relationship. That meant that when it comes to medical negligence, the restrictions or the considerations that are supposed to be made by the court should go beyond the mere general consideration of negligence. We should consider various factors. We should consider a standard so high that when we find definitely, or when the court finds that this particular individual is liable for medical negligence, more serious consequences, more serious penalties should be imposed. And just a by the way comment, this decision by the Supreme Court of Canada, in fact, does speak to the nobility of the profession. It speaks to the nobility of the profession. Now that we've talked about this theoretical justification, what could then be medical negligence? What are the elements of medical negligence? One of the cases that I want you to refer to with respect to medical negligence is a decision that was made by the Supreme Court of Zambia in 2007, the DAF Kopa versus University Teaching Hospital Board of Management. This particular case is very, very important as it speaks to various factors that concern medical negligence. Now, like the general consideration of negligence, the three factors that were mentioned in the famous Snell's case, Donahue versus Stevenson, still need to be considered. But when you refer to the standard of care, there is now a deeper consideration, because when you look at the decisions that have been made with respect to general negligence, you'd find that the consideration is made within the reasonable man standard. So would a reasonable man would have, if exposed to the same circumstances, would they have acted in the same manner? And if not, one has breached or has gone beyond the standard of care. But in medical negligence, we don't look at the reasonable man's test. And this is because we're not looking at an ordinary man, but rather we're looking at a profession, a professional. And thus a professional standard is created. This is what is famously known as the Borum test. When it comes to professionals, you don't consider an ordinary man, but you consider a person with the same expertise, a person with the same requirements and knowledge. If they were exposed to the same circumstances, would they have acted differently? And when it comes to specifically medical negligence, the Borum test is that when determining whether or not a medical professional or practitioner has extended or gone beyond the required standard, that's bringing about harm and injury, or they've acted below par, what we need to consider is whether or not their actions are consistent with the opinions of persons who are vested in that profession. Take that statement to be very, very serious. So if you're looking at general negligence, you're just saying it is a reasonable man's standard. If a reasonable man would have acted in the same way, you're absolved of your liability. If a reasonable man would not have acted in the same way, then you have definitely gone beyond what is expected of you, or you've acted below par, and thus you are required to definitely be liable for general negligence. But when it comes to professional negligence, especially with reference to medical negligence, we're saying there is need for us to consider whether or not a body of professionals, that is, let's say, for example, just as an example, the Health Professions Council of Zambia, HPCZ, would that particular body, if considered, in their opinion, that the actions of this practitioner who you are suing, who you are taking to court, are actually right within their own opinion? The Boram test was set in the case of Boram versus Friern Hospital Management Committee in 1957 in England, and was adopted in Zambia in the Edna Nyasuru versus Attorney General case in 1983. Of course, this was augmented further on by the Rosemary Warrior versus ZCCM and others case in 2005. It is showing you that this test actually is applicable, and later on I'll show you or point you to two cases where the test is still applicable. The professional standard requirement. The standard that is upheld by this particular professional is supposed to be one or in line with what a body of persons vested in the profession would consider to be within that particular profession. Now, the Boram test's second part talks about how or when can we consider a medical professional to have acted negligently. It further goes on to say that when it comes to responsibility, the mere act of a practitioner acting negligently, that is mere or generally, if we consider general negligence in this sense, we're saying just because a medical practitioner has acted negligently does not mean that you can actually sue them for medical negligence. So just on that particular basis alone, you can't sue them for medical negligence. There is need for a further test, a further consideration to be made in order for you to find them to be negligent. And this is the standard that we are using in this regard. Would a body of professionals consider that the actions of the person are in fact consistent, or they are in line with the professional guidelines? This is what really distinguishes general negligence from medical negligence. And the general we're considering reasonable standard, and then the medical we're considering professional standard. The existence of a duty is implied because there is a physician and patient relationship already. And if the breach of this particular standard going beyond the standard itself has in fact amounted to or resulted into injury or loss. And even if there is no loss or injury, if this standard has been breached or the person has acted below par, you can still sue them for negligence because their actions are inconsistent with the guidelines that are set by their professional body which they belong to. There is no requirement that there is injury or loss. You don't need to prove it. You just need to show that this particular person, this professional, has acted below par. Now, interestingly, or let me talk about the other differences. In terms of context, general negligence applies in everyday situations, whilst professional negligence or medical negligence, to be specific in this situation, apply to specifically to healthcare settings. Basically means medical negligence will only come about where there's a doctor-physician or doctor-patient relationship. General negligence is more simpler as compared to medical negligence, because as we have seen, even from the Boram test itself, if it is just the view of a body of professionals that the actions of a particular person are okay, then you can't sue. You cannot sue. Liability consideration is broader with respect to general negligence, as the reasonable care or the test for the reasonable care is more broad. But in consideration of medical negligence, it is unlike negligence. This is unlike general negligence. Medical negligence can arise from omissions of people. An omission can actually bring about medical negligence. Thus, the failure of a medical practitioner to inform you of the possible outcomes of your tests or your procedures or your surgery, whatever it is, the failure to tell you of a possibility of something actually is negligence, and it's medical negligence. If you go to the hospital today and your physician gives you medicine, and the medicine that you have been given actually overreacts with your skin, knowing fully well that there is a possibility of the medicine overreacting with your skin and the doctor does not do so, it means that they're negligent. This particular circumstance was confirmed by Mr. Justice Honorable Sakala. Chief, he was a serving Chief Justice here in Zambia in the Edna Nyasuru versus Attorney General case. The failure to inform you can result into liability. In fact, even in England, in Blythe versus Birmingham Waterworks Company, the failure of a medical practitioner, that is their omission, to inform you of the possibility of certain factors which are resulting from your relationship. It could be a wrong prescription. It could be them not telling you about the dangers of the procedure that you are about to undertake. Even if that decision is made in their best, with your best interest at heart, there is need for them to inform you. If you read the current case concerning doctor-patient relationship, that is the Kachasu versus Manda and others decision. This decision was made last year, I believe. In this particular case, we have a person belonging to the Jehovah's Witness belief, and I'm well informed that in that particular church, under their belief, they're not allowed to get a blood transfusion, no matter how much that particular procedure is needed. It's against their beliefs. So they move around with certificates and these cards that help them communicate such to doctors and medical practitioners, just in case they are found in a situation where they're unable to talk or they're unconscious or something like that. So this medical practitioner sees this as an oversight, goes out of his way and actually gives uh, blood to the patient. Of course, it saved the patient for some time, but the patient ended up dying. So in that sense, in that regard, the medical practitioner was actually in was actually found to be to have caused a tort to the patient. And if you look at it broadly, even negligence can actually arise from that, because there's an omission on the part of the medical practitioner. There is this particular rule that is in existence, and they have totally avoided it. It's an omission. So it is showing you the complexities of the relationship that is existing between the doctor and the physician. And no matter how good your heart, or how you centered yourself when it comes to making the decision for the patient, you can't make the decision for them, because this will result in other factors, including negligence itself. So the standard is quite high. It's quite high. Now, here's where now it gets a little bit complicated. The Borum test has changed, and it has shifted where it was set. The landmark case of Montgomery versus Lanarkshire Health Board, which was decided in 2015, now changes the look on this particular standard of care. The Borum test focused on setting a standard set by the medical, or a body of medical profession, body of medical opinion. But now the Montgomery test focuses more on the patient. So it is not about the opinion of the body of medical professions anymore. That is in England. And yet, in Zambia, we still rely on the Borum test, a test that has since changed. And when you look at cases, like for example, in the Attorney General versus Mulenga decision, which was made by the Supreme Court of Zambia in 2014, we find a scenario where a medical practitioner was injecting a patient. The needle of the syringe broke, and it went inside the patient's body. This patient noticed that she smelled some medicine and blood after the injection, but the doctor said it was an oversight. After a while, the needle starts affecting the patient. There's swelling on the leg. She starts palpating. Her heart rate is faster, and she starts experiencing a lot of changes which significantly affects her. She goes back to the hospital, and the hospital, after refusing that it could just be her reaction towards the medicine that she's been given, changes her prescription, and later on she requests for an X-ray. After the X-ray is conducted, it is found that she actually has a needle in her body, which entered, by the way, because of the negligence of the practitioner. So now we find negligence in this case, of course, because it is against the practices that were set, or that has been set by the body of persons. But we're still referring to the Borum test. We're still looking at it from the body of persons issue, which is the main problem that we're having with regards to medical negligence. We need to start considering this from the patient's perspective. And maybe that medical practitioner who failed to put the cannula on you and pricked you severely on your arm, that medical practitioner who was not able to address your challenges that you had and gave you maybe wrong prescriptions, caused you rash and all that, would be made answerable for their actions, because at this point, their role of giving you medication, which they think generally anybody should use to address whatever challenge that you've presented to them, would shield them from a possibility of a suit, because it is what a body of medical practitioners would think or would treat it as being right. So in order for us to address this problem now, there's need for us to move from the Borum test and start considering the test from the side of the patient. There's patient autonomy there. There's informed consent and so many other principles that focus on the patient, because the patient is the one who's now suffering the injury, and not us considering maybe setting the standard based off of opinions of a body of professionals. So that is my take on medical negligence. I have a few questions for you that I would like for you to take home with you as you go into thinking and pondering on medical negligence. The first one is, should we really continue sticking to a principle that has thus changed? A principle that is no longer applicable where we got it from, one that no longer is seen to be of benefit, as was stated in the Montgomery decision. Are these principles, or relying on the principles that we are currently looking at, a result of the negative effects of the doctrine of binding precedent? And if so, what could then be the solution to resolving these matters that are consistently currently affecting medical negligence or its effectiveness in this particular country? With those few remarks, this was the medical law lecture. I would now take questions if there are any from the audience.